If there is one thing that has been established in the last 3 days, it's that the present system of choosing judges is simply not working. Clearly, judges cannot be relied upon to choose the right people. So is the National Judicial Commission the alternative, or do we need to rethink the idea before we go for it? My guests are former Attorney General Soli Sorabji, former Solicitor General Harish Salve, and two of the Supreme Court's best-known lawyers, Prashant Bhushan and Abhishek Singhvi. Harish Salve, let me start with a simple question. After Justice Karju's revelations, after the confirmation that the UPA government tried to put pressure on Chief Justice Lahoti, and after the belief that perhaps the Chief Justice buckled under that pressure, do we need to change the way judges are chosen because the present Collegium system simply isn't functioning properly?
Karan, first of all, I must confess, this is not the only time when something like this would have happened. This is the only time where a person like Justice Karju, being what he is, has gone public about it. We have, personally speaking, I have been a votary of changing the system of appointment of judges. I think the judges, having taken this task upon themselves, have gone and landed in a situation where they have neither the machinery nor the equipment to assess the character of people being appointed as judges. And what we must recognize as a country is the kind of powers, constitutional powers, our High Court and Supreme Court judges exercise, and the kind of public faith which our judicial institutions exercise. There is no scope for error. One bad judge in a High Court is one judge too many. One corrupt judge in a High Court is one corrupt judge too many. If these are the rigorous standards we want to set for ourselves, people who are question mark have no place in the judicial system, and the judges have no way of ascertaining. We all very easily criticize the IB report, but then we can't use it selectively, use it to damn one person and to ignore it in the case of another person. And frankly, we all accept that the IB is not the best way to do it. The other day, Prashant had some suggestions saying that there must be a permanent body and that there must be a website where the average
Can I stop you, Mr. Salve? I'll come to Prashant Bhushan.
I think that is something we need to look at. So
I'll come to Prashant Bhushan's suggestions in a moment's time. I want to first stick to the question of principle, and I want to put the same question to Soli Sorabji. You've heard Harish Salve say that one bad judge in a High Court or Supreme Court is unacceptable. Justice Karju has raised serious questions about the decisions taken by 3 Chief Justices of India. Does that add to the urgent need to change the way judges are appointed? Do you think we need to relook at that whole thing again? Answer that question of principle first for me, Mr. Sorabji.
Yes, Karan. It's obvious. Let's understand why this Collegium system come into existence. It is because of the theory of committed judges which was voted by Kumaramangalam and the supersession of 3 judges who gave judgment against the government in Keshav Bharti. So in intent it was good, but in practice we find it does not work satisfactorily. And the question is, how can judges 3 or 5 with no machinery at the agency to help them come to the decision? No organization, no infrastructure can perform this task. And the events have shown that it's not being performed properly. And the main defect of the present Collegium system, to my mind, is that the judges have an exclusive voice. There's no other input, no other agency. So this all requires, to my mind, rethinking, rather replace it, or frankly, I think a judicial commission properly manned, properly equipped, would go a long way to solve the problem, though it may not be a perfect way.
Abhishek Singhvi, the law minister speaking in Parliament has said that the government is extremely keen to ensure the appointment of a proper National Judicial Commission. I know that when your government was there, you tried to set up a Judicial Appointments Commission, which is the same thing virtually with another name, but you didn't succeed. If Mr. Ravi Shankar Prasad goes ahead, will Congress support his endeavours, or might you do a flip-flop at this stage?
No, in principle, I do not have any reason at all to suppose that it will not be supported. Nitty-gritty details, specific provisions, additions and subtractions can be discussed. It was our idea, we pushed it. In fact, the BJP opposed it partly on the ground that it should be only a constitutional amendment. We also believe that it should be perhaps constitutional, but that it may be taking too long to do that, which is why an alternative was suggested. But let me speak on principle for a moment, Karan. The issue is much larger than an individual case. It's not the Kajju case or the Lahoti case only. I think this is something which is long overdue. And we also need to remember that you cannot merely substitute a collegium present system with a judicial commission. I am all for a judicial commission and preferably a constitutional one. But a system, because even the present collegium is in a sense a judicial commission. You need to put in the new judicial commission basic parameters. For example, today, do you give weightage on 5 criteria? I'm not talking about which it is, but do you read his judgments? Do you see his conduct? Do you test his integrity? Give some weightage, make a consistent uniform set of 4 or 5 parameters which the NJC proposed must apply. Otherwise, you don't want to substitute another cloistered, non-transparent body with a new one.
Okay.
And I think the main problem with the existing system is that it is not done in any method at all. It is just really 4 or 5 or 3 people, which criteria they apply, in which case, how much bargaining they do among themselves, what do they think, nothing is known.
Okay.
So certainly with those reforms, a new judicial commission is a must.
Let me take up some of those points made there by you, and I'll put the first one to Prashant Bhushan. Prashant, who will devise the parameters or the criteria on which judges are A, chosen, B, promoted, C, transferred? Because those are 3 important concerns that a National Judicial Commission will have to tackle if it comes into being. But who will decide those parameters? Will the judiciary decide them? Will the government decide them? Will it be a joint body that will decide them? Who does it?
No, the Judicial Appointments Commission could itself decide them. You see, the present collegium system is better than the previous system where the government had the dominant say in selecting judges, in the sense that the collegium system has certainly ensured a more independent judiciary. But having said that, it has not really brought in a proper, rational and good system for selecting judges, because the selections are non-transparent, they are quite arbitrary, and therefore leads to nepotism and all kinds of undue political pressure also sometimes. Now, what we need is a system where you have some device criteria on the basis of which the selections are made. Thereafter, a body which has adequate time to do those selections proceeds to invite nominations, etc. for these appointments. It measures the various nominees against those criteria in a proper way. This requires time. If you have to appoint 100 judges in the High Courts and the Supreme Court every year, and this body has to examine several hundred nominees for that for those 100 posts, it requires considerable time. This cannot be done by an ex officio body of sitting judges who are very busy with their judicial work, or even by the law minister or 2 jurists who are supposed to be appointed in this National Judicial Commission that the government has proposed. This Judicial Commission will only have the effect of giving more voice to the government in the matter of selection, and thereby compromise the independence of the judiciary. It is not going to lead to greater transparency or greater systematic study of the various nominees against an established criteria.
Can I stop you there, because you've raised 2 new fresh issues that I need to pursue, because I think they're very important. I'll pursue the first one with Harish Salve. Harish Salve, what you're hearing from Prashant Bhushan is the fact that this commission needs time. It needs therefore permanent members who can devote that time. If it's ex officio members who have another job to do, be it the law minister or sitting judges of the Supreme Court, then they won't have the time, they won't have the facilities to do a proper job on the commission. Therefore, do you accept his point that you need something closer to the UK's permanent National Judicial Commission, which is a full-time body, rather than the ex officio body that both the NDA and the UPA seem to be talking about?
Well, I completely agree with Prashant that the complete selection process can't be left to an ex officio judicial commission. So we need a permanent body which would screen, at least in the first instance, invite, screen and send up a list of people suggested. You can have above them an ex officio body which then from the list of selectees picks the number of people to be appointed. You can say if 10 are to be appointed, they send a list of 20 and they pick 10 out of those 20. So at least we have excluded all the other problems. I also want to take up one point, Karan. There is no question of executive primacy in appointment of judges. There is equally no question of judges or judicial primacy in the appointment of judges. We cannot exclude the political executive from appointment of judges, is my firm belief, which I have now come to accept. We cannot go by the fact that the last government has not been honest enough and therefore forever we must exclude the political executive from judicial appointments. They cannot have a decisive say, they must have a say.
Okay.
So to bring in a say of the government by itself is not wrong. But I completely agree with Prashant that 5 ex officio people, if you leave it to them to select judges, you first had the arbitrariness of the executive, then you had the arbitrariness of the Collegium, then you'll have the arbitrariness of the Judicial Commission.
All right. Let me bring you in at that point, Soli Sorabji, because so much of the functioning of this commission will depend upon the character, the nature, and I dare say, the alleged political affiliation of the people appointed to man the commission. Now, one concern raised by Prashant Bhushan is that if you have 2 eminent persons jointly chosen by the Chief Justice, the Prime Minister and the Leader of the Opposition, those 2 eminent persons, he believes, will actually act as representatives of the government, thus giving the government a sort of lopsided domination in the decisions of the Commission. Do you share those concerns that these 2 eminent persons will be, in effect, government representatives? Or do you think the fact that the Chief Justice and the LOP have a role in choosing them will ensure they are neutral and objective?
No, I don't really share that misgiving of Prashant. But the whole question is all depends on the composition. If the in this composition, I suppose the judiciary would have an edge. It will be exclusive. There will be political executive, there will be other people. But why do you assume the other people who are selected won't be independent in that sense and they'll be amenable to government influence? I don't think we should. The real point made by Prashant is there should be a full-time body which has time to go through this process, important process. It must have its own infrastructure, its own agency to carry out the work, which they can't do over a meeting over tea and coffee. That's important. But I do not believe that merely because 2 persons are to be selected in consultation with the Chief Justice and the executive, that would necessarily mean that the body will be not independent and not discharge its function of selection properly.
Abhishek Singhvi, what you're hearing from Prashant Bhushan, Hari Salve and Soli Sorabji taken collectively is a very interesting amendment to the ideas put forward by Kapil Sibal when he presented the judicial bill in Parliament during the last government. They're asking for that appointments body to be full-time rather than ex officio. Secondly, they believe it must have the infrastructure to do research, and that means it needs a fairly extensive infrastructure. And then there's a third thing which Prashant may not have mentioned here, but he mentioned it in his Hindustan Times article earlier today. This body must put up on a website the names of people it's considering so that outsiders, if they know something about those people, can directly inform the body about what they know. Would you be amenable to these additions which are add-ons to what Kapil Sibal proposed last time?
First of all, Karan, I think there is merit in the full-time proposal, but we need a lot of thought to go into it. If Prashant believes that the only and the entire body will be the full-time body, then there may be some practical problems, because you have here a tension between stature and full-time. So I think the only way we can achieve this, and that is the only via media I can think of, and I would like the virtue in having a full-time body, is to have a 2-level body. Call the lower level the full-time body, which call it a search committee, call it whatever, the names don't matter, but the function is there. So the two-level body is required, and the upper body, the top-level body, ultimately selects. Now, I don't think the full-time body in the sense Prashant means is going to be easy to work in India, because while you might have professionals doing it, you will not have the stature commensurate. And the second point is, I personally believe perhaps contrary to what Mr. Sibal presented, that the bill should be a constitutional amendment bill. In fact, I believe that having tasted blood over the last 25-30 years, the judiciary is not going to let go easily of this tremendous vast power of appointments to the Collegium. So there is every possibility that anything short of a constitutional amendment will be challenged and struck down even.
Okay.
Indeed, a constitutional amendment probably awaits the same fate. So I would want not only a constitutional amendment, but something which the two houses pass with rare unanimity.
All right.
Because that alone will give it the strength and the moral and the other backing which it requires to withstand a very serious judicial challenge, which ultimately the judiciary has the last word on.
Let me take up that very last point by Mr. Singhvi and put it to both Harish Salve, Soli Sorabji and Prashant. But I'm going to ask all three of you for very quick, short, sharp answers because we're horribly out of time. Do you believe, first Prashant Bhushan, that the judges will accept a National Judicial Commission regardless of whether it's done legislatively or whether it's done by full-fledged constitutional amendment? Will they accept it? A quick answer.
No, I think they will accept it. On this question of stature of the sitting judges being more than a full-time body, I think that full-time body can have retired chief justices, can have retired judges, etc.
Okay.
And I am not saying that the executive and the judiciary should not have any say in selecting that full-time body.
All right, but let's not
they
go
can
backwards.
certainly have an important say in selecting that body.
I want to escape from those details because I've really just got 2 minutes. I don't want to get into those details again. We've aired the different nature and composition, and that's very interesting. But I want to now ask that critical question to Harish Salve. Do you think there's a danger that the Supreme Court will strike down even a constitutional amendment that establishes a judicial body like the JAC? A quick answer, Mr. Salve.
Well, for a change, Prashant is the optimist, I am the cynic. I think this will meet some headwinds from the judges. I want to say this, Karan, governance has shrunk so much that the powers of the judges and their remit has increased. Shrinking it back is going to be difficult.
Okay.
And I agree with Manu, it should be a show of complete political and public unanimity, which will make the judges sit back and accept this amendment. Otherwise, it will face judicial headwinds. I can assure you.
Soli Sorabji is one of the most senior lawyers who's been both Attorney General and Solicitor General. What advice would you give judges who want to strike this down when it happens? A quick, short answer.
I don't think they'll strike it down, especially if it's been passed by both houses with almost near unanimity. And I think the judges will think twice before striking down a constitutional amendment. I think they'll be completely out of tune with the fed necessities of the time. And I don't think they'll do it, and I expect my judges to be mature enough not to do it.
All right, gentlemen, I'm afraid we've run right out of time. This is undoubtedly a subject that this program will come back to discuss repeatedly, because how we choose our judges is integral to what sort of justice we get, but it's also integral to what sort of democracy we are. My thanks to all four of you for joining me, and if you have been, thanks for watching. Goodbye. Good night.